My name's Sarah Chambers. I chair the Legal Services Consumer Panel, which has just been explained very well by Lola. So I'm going to go very quickly because I know we're running a bit short of time, but I'm continuing the theme of legal profession looking outwards to the customers rather than inwards to themselves. We've got some of that this afternoon and that matters hugely, but for me, looking outwards to our clients is even more important. I have a wonderful panel, and Marion will be glad to know there's no giant bears, just giant minds in my panel. And we're going to take you on a journey through the legal profession and how they deal with their clients. Chris is going to start. She's an educator, so she's going to start by telling you about how she designs training for would-be lawyers into how to make sure that they actually serve their future clients better than perhaps some of their predecessors have done, understanding the diverse needs of different communities. Then we're going to have Daniel, who is a pupil barrister. I think it's your 4th day of pupillage?
Week.
You're
Fifth week.
Well, you're pretty new as a pupil barrister, so you're not quite at Chris's level of teaching the people who haven't yet qualified, but you're very new. More importantly, perhaps, or as importantly, you are the founding chair of the Association of Disabled Lawyers, which makes me ask, why on earth has it taken us so long to have an association of disabled lawyers? But that's another question. So I think Daniel's going to talk about how to improve the integration of disabled lawyers and how that will help the client community, including clients with disabilities of all sorts of different kinds. And then we're moving on to Stephanie, who is Director of Justice.
The only legal director.
What did I say?
Yeah, that's very important.
Did I say a legal director?
The director, that may be implied.
Yes. Director. Stephanie is Director of Justice, so she's going to talk about access to justice and focus on people in all sorts of communities who have difficulties accessing our justice system for all sorts of reasons, and I think most of us are aware that that is a big issue at the moment. And finally, we're going right on to the judiciary, and Callie is going to talk to us about how the judiciary can improve the way it serves the entire legal sector, and in particular those who are users of the justice system. And she has all sorts of good lessons, I think, to learn. So I'm not going to say anything more. I'm going to move first straight on to Chris.
Thank you, Sarah. Coming at this from the legal education perspective is quite a hopeful perspective, because every year we get intakes of new would-be lawyers and people who want to engage with the justice system, and that's an enormous privilege to be able to be involved in that. I'm going to look at 3 strands of activity that legal educators could address in trying to ensure that we deliver legal services that our diverse society needs and deserves. And those come under 3 main headings. I'm going to look at classrooms, curriculum, and finally co-creation. So first of all, classrooms. 40 years ago, Duncan Kennedy spoke about the replication of hierarchies in law schools that feeds into the legal profession. And I think we're all here trying to figure out how we break down those hierarchies that we are struggling with. And anything we do in education starts in the classroom. And what we don't challenge in education, we accept. If we don't challenge the hierarchies, if we don't challenge the implicit bias, if we don't challenge those proxies of merit that challenge access to the profession, then what we are doing is we are telling these students that that is how it is. So we need to be active in doing that. Now, adopting culturally relevant, culturally responsive pedagogies is one thing that I would plea with other legal educators to do. That they speak to the whole student and recognise the systemic, the structural, the contextual issues that different students are dealing with. And in doing so, it's not only good for the students and for the staff, who get a much more enriching experience, as well as supporting a wider range of students and thus also potentially diversity within the profession. What we do when we do that is develop the students' own capacity as future lawyers to be able to deal with individuals as individuals from all of these issues, recognising that they will have faced lots of different structural, systemic and contextual issues, and bring them with them as their client. And it will make our students better lawyers being able to do that. And if they then develop that culturally responsive capacity within their education, they are more likely to take that with them into the profession. I would also make a plea to law firms when we are looking at top-ups or packages to address specific areas of diverse needs, that we do it in a way that is culturally responsive, that we don't assume that these things can just be bolted onto a person's existing perspective and training, that we do it from the ground up, acknowledging all of the other factors that play into these very complex issues. Secondly, curriculum. I'm going to pinpoint two main things because there are so many things within curriculum we could do, but ethics and the impacts of technology on legal services. In legal education, ethics has been somewhat of a merry-go-round on where we put it in and what stage and how much. But for me, embedding ethics as a core part of the curriculum is absolutely key in getting this diverse, these needs of a diverse society. It's not only about the internal client-focused aspects, it's about those wider legal values that we should encourage students to consider as part of their professional makeup: the rule of law, equality, and importantly, access to justice. If we don't put ethics in the curriculum, we miss that opportunity to really examine those, as Donald Nicholson put it, legitimatory principles such as access to justice that underpin the legal profession having professional recognition. The next point on my curriculum review is technology, in particular law tech, which has already been discussed. Many are focused on client solutions, many on end user solutions, and all impact upon the way that we can deliver legal services. What we want to look at in terms of students is ensuring that we equip them not just to know about the types of technologies and make them tech fans. It's about actually being able to critically apply those technologies in context, to harness the opportunities and evaluate risks of technologies. It requires new ways of thinking about problem solving, new ways of thinking about processes, essentially a new way of thinking to our lawyer toolbox. And it also links back to that renewed need for a focus on ethics. When technology, in particular AI, meets the legal profession, we then have two sets of ethics colliding. The issues inherent in AI, bias, transparency, accountability, and then how those align with the codes of conduct specific to the profession. The other risks that technology could bring is that race to the bottom in the delivery of legal services. But if we work with our students to provide them with an ethical framework and in a culturally responsive way, then the risk of this is lessened. My final point for legal educators is that of co-creation. Universities are in an ideal position to co-create solutions to actively support the work on delivering legal services. Tying in with the curriculum point above, there are particular opportunities for doing this in terms of using technology, both end-user focused, but also practice and systems focused. Great efficiencies can be made within legal practice because of technology. But how do we support small law firms or solo practitioners in being able to access those greater efficiencies? Often the barriers of cost, market confusion, legacy systems are the greatest in that area of the sector. That's also the area of the sector that is often providing services to areas of unmet legal needs. So the role here for universities is twofold. We can access greater expertise across discipline areas. We can tap into computing, to law, to service operations, to design schools, to come together to create solutions. They can do this as a business-to-business law clinic, perhaps, where teams of supervised students support the navigation of these complex areas of law tech adoption for small and solo practitioners, in understanding service processes, impact evaluations, and the contractual, jurisdictional, and ethical issues that these things bring with them. Knowledge partnerships, I would like to plug, a great way of drawing down money from the government to create a tripartite relationship between the expertise that exists within universities, a talented graduate, and a small external partner, in our case perhaps those small law firms. The aim would be to deliver a process or an improvement in service that would serve the public. So these three strands coming together, classrooms, curriculum, co-creation, should equip our students with being in the best possible position to deliver those services that our diverse society most needs.
Thanks very much indeed, Chris. We probably should move straight on to Daniel. Collect up your questions for the end of the panel.
Hi everyone, I'm going to take you on about a 7-minute journey, and hopefully that will bring out all the points I want to make. The end goal of the journey is legal services that represent disabled people in the community. To start the journey, you need to begin in education. Disabled people are still excluded from mainstream education, mainly because mainstream education cannot support them. So that's the starting point. In order to get a profession or professionals that represent the whole community, you need to make sure that young disabled people are encouraged to enter the professions. And to do that, more outreach work is needed. There's been some really good outreach going around social mobility and getting people from different backgrounds into law. That now needs to be extended to encourage young disabled people to do the same. That can be done in two ways. Your group or body can organize and collaborate with schools of all different kinds to plan workshops, educations, and so forth, where you can get disabled lawyers to come in and tell young people about what they do and the impact that can have on the wider society and the consumers that we serve. Once you've done that, and hopefully the barriers haven't gotten away too much, that those students will be able to go into higher education. Again, more outreach work is necessary because we're still at a point where disabled lawyers aren't as visible as other lawyers. So we need to make sure that outreach continues all the way through. And then when universities and education bodies need to make sure that they properly understand all the kind of reasonable adjustments that are available to students to give them an equal opportunity to do well in education. as you all know, and if you are able to get into working in legal services, your educational background isn't really taken into account. One of the other things taken into account is your experience, your work experience. Disabled people are excluded from work experience because not everybody providing work experience is offering an accessible program or buildings or whatever it may be. And if disabled people can't get equal access to work opportunities and they can't get that on their CV, and that impacts their chances of getting into the profession. That's another part of the thing. Once they've got some experience and education, they can then start applying to law firms, chambers, and so forth to get a training contract or pupillage. That recruitment process also needs to improve because the disabled applicants may not have the same level of experience because either they weren't able to access it or they have to spend the time managing an impairment. That needs to be taken into account. This seems like disability confidence will only get you so far because that's banking on applicants having a certain level of experience. And in actual fact, it's whether you got 1 million pupils or 3, you pretty much have an idea of what goes on. So that needs to be taken into account. And then when you're interviewing disabled applicants, you need to let them know they are welcome when they apply, and they can ask for reasonable adjustments at every step. Once they get into the profession, we need to break down the stereotypes and the traditional working practices that take place. The idea that one needs to work every waking hour isn't necessary. It's about being smart in the way you work and being able to do the fundamentals of the job is what needs to be considered, not how many hours you can work. And it's about working in a way that works for you. So if you're providing good legal services, it doesn't really matter how you do it. So that flexibility needs to be there. We also need, and that's important because if you can get disabled people into a profession, they can give better advice in all the different ways. That's been spoken about in the videos at the beginning, and all the other speakers. I don't really need to go that again. So, that's one thing. The second thing is being able to access all the buildings that one needs to access, including the courts. We are providing a service, a public service, and our buildings ought to be accessible to all. And I'm not talking about ramps and lifts, I'm talking about all your ways in which we can break down barriers like hearing loss, better communication, better understanding. And obviously the courts are a big issue. An accessible courtroom is a rarity. and that really needs to change because we can't do our jobs and consumers are excluded from being part of a process which is fundamentally about them. I've heard of consumers not being able to access the courtroom when the whole case is about them. And that's injustice. And then, yeah, I've seen disabled people having to wait for their representatives to come out of court and explain to them what happened inside. And that's not right. And when you put all that together and you break down all these barriers, both the consumers and practitioners, you get to a point where the profession better reflects the society we serve. And in order to do that, we all need to work hard in making that happen. When I talk about disabled people, it's easy to look at it in a general point of view. But we also need to be aware of the intersectionalities within the disabled community. Yeah, we need to make sure people of all different backgrounds who are disabled are equally included in that. This month is Black History Month, and it simply isn't enough Black disabled lawyers. There aren't enough disabled lawyers anyway, but that impact is worsened when you look at the individual sectionalities. And that's the same for consumers. If we can't reflect them, we can't communicate in a way that demonstrates we understand their struggle. And that's important for the advice and the service we give. And if we really need to do that. I was gonna say something, but it's gone. And I think my final point needs to be that, yeah, law is about interpretation. We're interpreting legal constructs and cases and judgments, and our understanding of the world influences how we do that. And we can't do that fairly, and we can't do that adequately if we don't understand other people's experiences.
Thank you very much, Daniel. Some important lessons there. And straight on to Stephanie.
Hi. For those of you who don't know Justice, we are a law reform and human rights organisation. Our aim is to make the justice system more accessible for individuals, no matter what their background or circumstances are. We look at systemic access to justice issues and through our working parties come up with recommendations for reform. In the short time that I have, I want to pick up on two themes that relate to the delivery of legal services to our diverse society that have come out of recent working parties. Those are the role of technology and the location of legal services. The role of technology, we've already heard obviously quite a bit about this already today, and how it can be used to both enhance people's access to justice, but also how it can exclude some people. Obviously, the pandemic accelerated greatly everyone's use of technology, and including the delivery of legal services. And I think that there are valuable lessons to be learnt from this. It has shown us how technology can better facilitate delivery of legal services for some people, and equally how face-to-face advice remains vital for others. But at Justice, we think that the use of technology to deliver legal services goes beyond just the use of Zoom and Teams to deliver legal advice. Particularly in the context of the online, the HMCTS reform programme, we would like to see online advice integrated into that. A platform where A user could commence with an online triage that asks them simple questions about their dispute to establish what it is about, and then directs them to options for specialist legal advice. It would include local in-person advice providers, as well as services delivered remotely via a video chat function built into the platform. In particular, remotely delivered advice should be augmented by client-sided assistance for those who need it, providing practical, technical, and emotional support. Beyond better facilitating the delivery of traditional legal advice, technology can and is already being used to change and democratise the actual form in which legal advice services are delivered. For example, there are now a range of automated online tools that help individuals build cases or claims. Just a couple of examples are Law for Life and Advice Now's Work Capability Assessment Submission Tool, which helps advisors and appellants create appeal submissions to the SSCS Tribunal, and Law Fairy Pro Bono product, which delivers a complete emergency housing application almost instantly, following a guided Q&A. Find Others is another example of new ways to use technology. It's a website that brings people together around legal issues, finding people with similar experiences to join together to use the power of numbers to resolve their issues, either before they get to court or to facilitate group claims. Another example is the Affordable Advice Service from Law for Life, aimed at addressing a range of barriers to parents seeking advice in relation to family disputes, including fear and confusion about the prices, the high cost of advice, and a lack of confidence. It integrates online legal information with opportunities to receive unbundled legal advice from a resolution lawyer at a fixed rate. I think we need to look at more tools like this and encourage people to develop more tools like this that harness the power of technology to make legal advice more affordable and accessible to people. Having just talked a lot about the role of technology, but acknowledging that face-to-face advice delivery still remains vital for many, I want to talk about the physical location of legal services. It's well known that legal issues often cluster together, both with other legal issues and with non-legal issues. In particular, housing benefits and debt issues commonly occur together, and it's easy to see how the inability to work leads to a loss of income, and if an individual cannot access benefits, they may be unable to pay rent and face eviction. In light of this, there's a clear benefit in co-locating different types of legal advice together. One successful example of this is the Westminster Citizens Advice Shop, which brings together a number of organisations providing advice across a range of issues. Clients are triaged to understand what issues they are facing and then directed to relevant organisations that they can see all in the same place on the same day. Legal issues also frequently occur along non-legal issues, for example, ill health. Justice has previously highlighted the benefits of health justice partnerships, that is, access to legal advice and assistance through health services. This may take the form of co-location of legal advice in healthcare settings, direct referral systems, or multidisciplinary team working. These have the dual benefit of improving the delivery of legal services by reaching individuals who may not otherwise have accessed legal assistance, as well as improving health outcomes by addressing the underlying social and economic causes of ill health. Our report on access to justice for separating families, which is published today, has also highlighted the advantages of local alliances, partnerships, and networks of legal and non-legal services to ensure that families can receive help with their problems as early as possible. For example, the Community Legal Outreach Collaboration KEAL, or CLOC, provides service users with a volunteer community legal companion to coordinate their multi-agency support from law firms, mediators, citizens' advice, and domestic and sexual abuse survivor support services, and others. Family Hubs, a DfE initiative that intended as a universal front door for families, offering a one-stop stop for family support services, are another example. However, even where such models exist, individuals may not know that they do exist, or they may lack the confidence to access them or other advice services. This is often particularly true of those experiencing vulnerabilities. It's therefore important to think about the location of advice provision. It should be situated in places or services that individuals, in particular vulnerable or hard-to-reach groups, already come into contact with. As I mentioned earlier, this is one of the advantages of health justice partnerships. But there are other places too, in community centres or housing associations with in-house benefits advice, and some advice providers located in food banks. Community outreach in marginalised communities is particularly important due to the intersecting barriers they often face in accessing support. For example, during our family working party, Southall Black Sisters highlighted to us several intersecting barriers preventing Black and minority ethnic women, particularly those suffering abuse, accessing the legal and information and advice they need. Those barriers included immigration insecurities, fear of reprisals from family and community, shame, isolation, fear of court as a punitive authority, and lack of awareness of where to get help. Community outreach can be done through partnerships with trusted people within marginalised communities and by encouraging support organisations who work with those communities to become part of the hubs or physically co-located services that I mentioned previously. For example, Forward UK, an African women-led organisation working to end violence against women and girls, supports individuals and families to access support and legal assistance. It uses a model of engaging with community champions to reach out to marginalised members of the communities, rather than expecting people to find their service on their own. Understanding the different modes of communication within communities is also important, and here technology comes back into the frame. Messaging platforms such as WhatsApp and Telegram are some of the most commonly used methods of sharing information within communities. So, in summary, in answer to how to deliver services our diverse society needs, I think we need to think about how we can harness technology to democratise legal assistance and advice, whilst ensuring that those who require face-to-face support continue to receive it. And secondly, consider the physical location of legal services in order to ensure that they reach marginalised communities and are part of a package of a broader holistic support. Thank you.
Thank you very much, Stephanie. That was great. And now, last but not least, we have Judge Call. Take it away, Callie.
Well, Sarah Chambers invited me to this, told me I had 7 minutes, and I've got 9.49, and I've got this clock in front of me. That's not the point. Telling a judge she has 7 minutes to put across quite a complex topic, impossible, but I'll try and be short and interesting. You've heard from the Master of the Rolls this morning, and I certainly was very encouraged to hear that there's been a level of recognition by senior judiciary of problems within the judiciary. That is my crusade. That is now my life's work. But today is not about that. Sarah's told me I'm not allowed to, so I won't. But I am a frontline judge in a socially and economically deprived area of London. I've been sitting since 2009 and full-time since 2015. I'm Indian. I'm female. I come from a non-traditional background. And as a result, sadly, of things that have happened to me within the judiciary, I'm now permanently disabled. I represent, therefore, for the judiciary an embarrassment of riches, but I'm not sure they appreciate that. The views I express are mine. They're expressed on behalf of the Judicial Support Network as well, of which I am chair, and progressive reformist judges, but they're not expressed on behalf of the judiciary. I'm honoured to speak to you all, but the first point I'd like to ask you is this. What does justice mean to you? What do ethics mean to you? Are we doing other people a favour by being diverse and being ethical in our conduct? No, we're not. The people we're doing a favour to is ourselves. It's about our standards. It's about upholding our principles. And so please don't look down and think, well, I'm doing this poor person. I'm being so kind and fair to you. You're not. You're being fair to yourself. And please remember that. My court at Wood Green, as I've said, is we have the most, I think we're told, the most number of languages, races, religions, social deprivation, gang violence. We have a proliferation of serious mental health issues, psychosis, schizophrenia. That's just the judges. Not really. Not really. But we are affected by chronic underinvestment, as is the whole criminal justice system, and you've seen the bar were on strike. That created incredible stresses for those who are unrepresented and for the judges. Can you imagine? Defendant after defendant appearing on a prison video link, not from England. English isn't their first language. They have no representation. The last time they saw a lawyer was in the magistrate's court. And the next time they see this fat Indian woman with a wig on. How is that going to help? Well, We do, and I think we've done a really good job. The first thing is to reassure them that we're there to protect their interests, explain what has happened on the strike. Sometimes we have interpreters at Wood Green interpreting for them in Pentonville. I cannot tell you how badly that goes. It's really not good. But we do our best, and we've reassured them, and I'm pleased that the strike has now ended. But that created a problem. This week, my trial is a sexual complaint. Both the complainant and the defendant are deaf. So I have a proliferation of British Sign Language interpreters. It's going very well, thank you, and the jury will be out tomorrow. The jury have been excellent. Last week, 2 16-year-olds, one had groomed an 11-year-old online, on social media, house party, etc. Went round, both had sexual contact with her of a particular nature, filmed it, and then it went online. These are our real lives, and they concern all sorts of different people. But if you want to see ethics and diversity in action, and I'm glad I can depend on Stephanie to confirm this, she was a juror at my court in the summer, apparently, I didn't know. If you want to see how it works, come to Wood Green and see our juries. See how wonderful they are. Sometimes I have tears in my eyes because I just see the most diverse community, from Hampstead and people who live in £15 million houses, and I know that because I see their addresses on the sheet, right over to Camden, to Barnet, where we have a heavy, quite strict Jewish community, to Haringey, to Enfield. And I was telling Stephanie of one case where a Hasidic Jewish gentleman said, I can't sit with women, I have to sit separately. No problem, sir, you sit there, we'll all sit there. But when you go into the jury room and you're considering your verdict, you have to sit around the same table. You can sit in any combination you want. And he said, no, totally understand that, of course, it's no problem. And the next day, I saw them coming in, and my usher said that one had baked him biscuits, and the next day he baked the lady biscuits, and the lady was in a hijab. So, you know, we have the best things, and they do listen to us. So if you want to see how it can work, and it does work. So moving on, I can see the clock is ticking. 3 areas I want to tell you about. First of all, our oaths in the Bangalore Principle, very briefly. To introduce you to the Equal Treatment Bench Book, for those of you who don't know it, I'd ask you to look at it, use it, adopt it, and do it as we are doing now in my jurisdiction, which is to blend it into everything. I'm a judicial college tutor as well. So that wherever barristers and judges and solicitors and legal executives look, they will come across it. They can't avoid it. So that is a way of making sure we don't just have a policy, but it's used in practice. It's only the beginning. Don't think I'm saying it's perfect. The chapter on race really could do with a lot of beefing up. And I've already spoken to the general editor about it. She's just taken over. And I'm sure because it develops all the time, and we're constantly getting updates about it. So please do look at that. And also a little bit about the other judges that I've spoken to in preparing for this. Different jurisdictions, very diverse backgrounds, religion, disability, whatever, but no virtue signallers. I do not allow virtue signallers into the Judicial Support Network. I don't need any of them. There are plenty of those. So let's go to the Equal Treatment Bench Book. I was going to try and have put up the index for you, but it was too long, and this is the index. This is not my speech, it is the index. So it tells you about everything, and it's regarded by many at the bar and others, judges too, as being woke. Oh no, it's the ETBB again, is it, Callie? But what they've done is, at the Judicial College, the scenarios are geared to the Equal Treatment Bench Book. The Sentencing Council's guidelines are geared to the Equal Treatment Bench Book. The compendium we have for trial and sentencing remarks, legal directions, are geared towards the Equal Treatment Bench Book. So one way or the other, you're not going to be able to escape it. And all I'm saying to you is to, in your different regulation, in your different areas, make it real and make it relevant and make it compulsory, but not in a threatening way, in a way that it just becomes weaved in so you get used to it and you take it on board and deal with it. I wanted to take you through a few bits of it. It's got great areas on mental health, on social exclusion and poverty, on different health conditions. It's got glossaries at the end which explain so many differences of different communities. Of course it's superficial, it has to be, but it's a really good introduction and a really good place to learn. And those who use it have said so many times, I wish I'd used it before. And we have that at the college when we're training people. They say, gosh, I hadn't looked at this until I had to answer this question. I realised the answer was there. And now I've looked at it, I could have used it in so many cases. So please do look at that. Moving on from there, I can, the various gripes, I agree with Daniel, and if there's anyone here from the government or HMCTS, can they kindly listen? We have no disabled access for prisoners at Wood Green Crown Court. If we need to sentence someone, one of our judges, Joanna Greenberg, had to go to Reading. Wood Green is in North London. The only two courts we could have gone to are Isleworth and Southwark, and they were full, so she had to go to Reading. Pentonville is full of disabled people. They have to come to court. All we need is one slope and one chairlift. Everything else is disabled friendly, our court. It's all flat, no step access. I'm just saying that. But others, well, immigration, children unrepresented, the charities that used to help them closed down without funding, leaflets printed in English, the lack of awareness of the way in which those from other backgrounds remember time. For example, when is the harvest in Afghanistan? That is how the person is remembering it, but how many of us know the answer to that? Civil judges say earlier engagement, more mediation, exactly what the Master of the Rolls was saying. They say much reduction in the adversarial nature of the proceedings, which allows those with deeper pockets to delay or not disclose or obfuscate, to refuse mediation. We need better publicity. We need it to be much more available. And one of the judges on the network suggested a compulsory conference with a barrister paid for really early on to deal with debt management, possession actions, so that those could be dealt with in a much more effective way than litigation. I don't care that time is running out, Sarah. You try and stop me.
I probably will.
You won't. From the Employment Tribunal and the EAT, Employment Tribunal, we need recordings, we need fairness, we need people to have faith in the Employment Tribunal. At the moment, I hear so many people don't. I can't speak about that myself. I'm just saying that it is important. Family, again, people feel that they're not, that their intersectionality of racial and cultural issues, of language, of lack of money, of lack of adequate representation. People feel that judges and the representatives, if they're there, are biased against them, social services, care agencies, and matters of that kind. And again, we need to really do so much more. Is that red sign at me?
Yes.
Okay. All right. Well, okay. Well, I'm upset about this now. But I'm just going to say a couple of more things.
Quickly.
Honestly, wouldn't you rather hear from me or Sarah? Okay. So, first of all this, treat others as you would expect to be treated yourself. That is all we have to do. If you need one lesson from today from me, just imagine what that person is going through. Just imagine what they're feeling like and try and understand them and treat them with respect. Treat people impartially. Really welcome diversity. Don't just tolerate us. Welcome difference. Don't ever say to me, I don't notice what colour anyone is. Why don't you? Why don't you notice the person is disabled? You should. And you should welcome cultural difference, welcome every difference. There is so much more we can do. So I've now finished.
Thank you.